So there you go. Let's turn our attention now to the Senate. Yeah, the amendments of the Electoral Act is still generating strong reactions, with many Nigerians unconvinced that lawmakers have gone far enough to safeguard the integrity of future elections. While supporters call it a workable compromise, critics say it leaves key fears unaddressed, especially around discretion and accountability. So, what are the legal implications, and does this amendment truly answer concerns Nigerians raised? Well, joining us now is Victor Giwa. He's a legal practitioner, among many things. Good morning. Thank you for coming on today on the program.
Yeah, good morning, Timberlake. Thank you for having me.
So, a lot did go on yesterday. Many were watching, with keen interest. So, for you, from your perspective, having also been involved in elections and the law and how some of this play out eventually, what's your impression of what happened yesterday?
Well, thank you very much. Firstly, what played out yesterday in the National Assembly is a very sad commentary. And the National Assembly is supposed to be a sum total of leadership that should promote national development, national integration, national security. The National Assembly should be the sum total of persons who are advancing the development of this country. And it's very sad that what we saw yesterday diminishes that particular perception, that belief. And I don't know whether that should be, especially in the Senate. And why did I say so?
Yeah.
The members of the National Assembly should be one of the best in terms of leadership, in terms of people who understand the fact that at this time in Nigeria, Nigeria should be put in the map in terms of development, in terms of direction, in terms of deliberate progress. Now, we are talking about electoral act, electoral transmission of result. And the National Assembly is giving excuse about something like, oh, there's possibility of network, we not having network, a lack of internet connectivity, where I saw yesterday, one of these countries hosting the 2026 World Cup, they're saying they're going to use robotic dogs to monitor and supervise the 2026 World Cup that is coming up in the next 4 months. And we are talking about the problem of not having network. And what is the issue actually? National Assembly should be tasking our MDAs, they were ministry, department, and agency, on how they can be going about thinking of serious technological development, setting targets for these MDAs, for INEC, at a time where Nigeria has, every time you wake up in the morning, our young men have been arrested by EFCC for hacking electronic, intercepting emails, bringing down networks in other crimes, and even the world is wondering what kind of young people we have. We are still talking about network. But now let us go to the real issue.
Yeah.
Now, firstly, do we need to have this debate and this headache about whether to incorporate electronic transmission of results? And my question, then the answer is simple. First of all, INEC, I think the problem starts from even the National Assembly themselves, Section 60, subsection 5 of the Electoral Act 2022. And I need to say this. The Senate President misconstrued or to say that he intended to mislead the public when he said that the intention of the Senate was to retain electronic transmission of results as it was contained in the Electoral Act 2022.
Or was it that the people misunderstood him? Because what he said was that they retained the provisions of Electoral Act 2022, which means INEC can transfer it based on their own discretion.
Yes, but okay, that is what he said. But what he implied is that left for INEC to determine how it should go about the transmission of results. However, the INEC regulation and guideline, clause 38 and 48 of the guideline. But let us start from section 60 sub 5. Now, section 60 sub 5 of the Electoral Act says that the presiding officer shall transfer result, including results of the accredited voters, result of the ballot in a manner prescribed by the commission. Now, the object there is transfer.
Yeah.
So the presiding officer shall transfer. Now, if you go and look at section 64, sub 4 of the Electoral Act, it said the coalition officer shall not announce any result except it comes to understanding to verify that the result transferred to it correspond with the transmitted result. Now, the word transmitted now came in under section 64 sub 4. In section 60 sub 5, the word used for the presiding officer is transfer. Did you get it now?
Yeah.
Now, in solving that problem, why section 60 verse 5 said that, section 60 sub 5 says that the presiding officers shall determine the transfer of result in a manner prescribed by Annex.
Yeah.
What is the manner prescribed by Annex? Section plus 68 of the INEC guidelines and 48 told us something. It said the election shall be by electronic transmission of result. Electronic transmission of result or transfer of result. Now, the problem we now have is that the Supreme Court, in the case of Peter B versus INEC and Atiku versus INEC, now says, look, gentlemen, electronic transmission of result is not mandatory under the Act. And you agree with me. I was blaming the Supreme Court.
Under the Act or under, okay,
under the Electoral Act.
Under INEC guideline is different.
It's different.
From what's under the Act.
Yes. So the Supreme Court said, no. Electronic transmission of results is not compulsory, it's not mandatory under the Act. So, unlike the position of the petitioner, who says that, oh, the election should have been transmitted electronically. The Supreme Court said, no, look at your Act. And you could see that the words in section 65 talk about transfer. Section 64 talks about transmission. So you will now ask, what is the implication of transfer? And do they intend that it will be electronically transferred or manually transferred? I need to say that the election in Nigeria is hybrid. It is not electronic. And what do I mean? When you want to cast your vote, the first thing you do is come with your voter's card. So it's manual. You come with your voter's card. When you get to the polling unit, they now do what we call accreditation. Now, that's the duty of the BVAS. So you are bringing out electronic. Now, what the BVAS does is authenticates the veracity of your voter's card. Then the next thing the BVAS does is that it now verifies by what? Fingerprint and facial. When you have been verified by the BVAS, they now go and check the manual register. So you could see that it's an hybrid. You come with your manual PVC, they check you on the manual register, then you use the BVAS to accredit and to transfer the results. So it is an hybrid.
So the thing is before we go to that explanation and then back to what the Senate actually did yesterday.
Yes. The
parts where the court did say, look, transferring or transmitting those results as the INEX guidelines may have provided, the second part of which tantamount to electronic transmission, what the court says is if they do that, that invalidates that. In fact, that's contrary. It's not even on the law in the first place. So they shouldn't even think about that. So one wonders here, when they say, look, your guidelines falls flat in the face of the law, the Electoral Act. But we also do know that different organizations, different groups, they all have guidelines that they abide by. As a matter of fact, doesn't the NJC themselves have guidelines? We've seen CJNs, all this fight. You remember once upon a time where there was this massive fight about, the CJN must go, CJN cannot stay. They were all relying on their guidelines and policies, of which they say if you violate it, it will be punitive. Are they in the Constitution of Nigeria? Don't they all stick and abide by that as though it's a religious book? So why is it when it then comes to this one with INEC, then they're not beginning to be specific and tell you, oh no, it may be in your guideline, but it's not in the law?
Yeah, that is the unfortunate thing. The Supreme Court made it very complex for us, actually, because the Supreme Court now said, look, the issue of electronic transmission of results is contained in your guidelines. However, putting the Act and the guideline, the Acts reigns supreme. That if this issue of electronic transmission of results is key for you, you should make sure that it is embodied in your Electoral Act. And that is what the Senate intends to do. And my own position about the Senate is that if that is what the Nigerians have, if what Nigerians have decided, it shouldn't take you time to incorporate that part directly into the Electoral Act and made it very simple. Section 60 sub 5 should now say that the presiding officer shall transmit the results from the polling unit. Now, we should not mix it up. I saw a lot of civil society groups say that, oh, and I saw some persons, oh, you must transfer from the polling unit to the IReV. The Supreme Court said, no. There's nothing, your IReV.
It's not a coalition.
It's not a coalition system. As a matter of fact, one of the rulings in that decision is that IReV is not a legally recognized coalition mechanism. That IReV is just a tool to inspect the result online.
In other words, the coalition centers
is different from IReV.
So that still stands.
That is what that's the stance. So even if they did that amendment, and that is why I'm blaming the Senate. The Senate should have looked at the Supreme Court decision. They have experts, they have senior lawyers to have studied that decision of the Supreme Court. Because it is not enough for you to say that, oh, you will do electronic transmission of result to the IReV, and now we start dancing that, oh, you have done. No. The Supreme Court even went further to say that the result, the evidence you get from IReV is not even valid enough to define issues in the election. Did you get that?
Somebody
that you cannot even win the result from IReV.
What does the Supreme Court want? Well, I have got questions for you. Go ahead, please.
Well, thank you, Chamberlain. I was actually hoping that you would actually, discuss what the Senate said. But before we go there, indeed, let me ask, just for the sake of those who are wondering what this hullabaloo is all about. One of the things that CSOs are saying is, if we do this amendment, we will be able to get more people to vote because it will instill more confidence in the voting process and all of that. So let me ask you pointedly, how much, in your opinion, do you think this amendment will affect voter apathy, for or against?
Now, firstly, as a member of the civil society, I'm an accredited INEC observer, and I've been doing that for the past 10, 15 years. Now, we have always said that when there is electronic transmission, when there is innovation, technological innovation in our voting process, it will increase the confidence of Nigeria. And the Supreme Court even held that position. The Supreme Court said in that judgment that the introduction of IReV may boost the confidence of Nigeria, but non-usage of IReV does not invalidate the process. That the best IReV does, it boosts the confidence of the people, it encourages transparency. However, the failure to use IReV, the failure to transmit results to IReV does not invalidate the process. Now, so that in terms of the introduction of IReV, the use of the beavers, and the electronic transmission of results, what it does to the electoral process, it builds our confidence. It promotes, transparency. People now say that, okay, we can now at least give INEC the benefit of doubt, give the politician the benefit of doubt, that now they can now go to the polling unit and cast their vote. However, the process is not complete. It is not enough for we to have electronic transmission of results. We must understand the matrices of that judgment. So people should not just go and say, oh, if you have electronic transmission of results, then you have a transparent process. No. For example, some people have said that IReV is not a coalition device. And even the Senate did not even look at Section 62, sub 2. You have the Electoral Act. They look at Section 62, sub 2. Section 62, sub 2 said that there shall be a national electronic register of results. So what is the purpose of National Electronic Register of Results? Could that be the database where all the all the results that have been transmitted should be harbored, such that if the result contained in the National Electronic Register of Results, as contained in Section 62, sub 2, that when that result is at variance with the manually collated results, that the result in the electronic register as contained Section 62.2 should prevail. People are quiet about it. All what we are saying is, oh, IReV. Supreme Court said, no, IReV is just a tool for looking at the results online. It's not a coalition device. It is not recognized under the Electoral Act. There is no mention of IReV in the Electoral Act as I'm talking to you. So, talking about what the Senate did yesterday, I am saying that the Senate should have
we'll come to that.
Conclusion on that part.
Mr.
That the electronic transmission of
just
results,
a second. We'll come to that.
Should be a coalition center. Okay.
Just a second. We'll come to that. You know, we'll come to that part. But the question I asked, I'm not sure it has actually been, answered. If anything, you have even made it more complex, because now you're saying that as far as the Supreme Court is concerned, the fact that we have electronic transmission doesn't, doesn't really make it sounds like it doesn't really make so much of a difference. So if we have this section 62 sub 2, which we said the commission shall compile, maintain what is known as the National Electronic Register of Election Results, it will seem like everyone is quiet about this. So if we already have some kind of electronic initiatives in the law, on the one hand, why aren't people talking about this? On the other hand, if, as you said, our elections are hybrid already, how significant, in your opinion, will this amendment be? Because I don't see much has changed. I mean, it's not real time and it's not exclusive. It can't be real time because of the challenges of network that the Senate raised, and it can't be exclusive because we want some kind of validation elsewhere. You've also drawn the difference between transmission and transfer. We'll come to that later. But how significant is this amendment that the Senate is proposing if it's still going to be hybrid, and it sounds like you're saying it's not making much of a difference?
I have answered your question. I think the only reason is because the answer did not make you feel good, because as against what is in public perception. I said it, but because you were not too, it didn't make you feel cool, so you didn't want to absorb it. What I said is this: that assuming INEC, the Senate, pass that section, that clause 3, that says there shall be electronic transmission of results. To where? To IReV. Even Senate mentioned IReV. I heard one of the senators mentioning IReV. I am putting it to you that the Supreme Court has even went further to say that IReV is not a coalition device, that IReV is not a coalition center, that IReV is not a coalition system. It even went further to say that if you download every result you have in IReV and you bring it during election petition, it is not enough to establish facts in your petition. I am not speculating. I'm telling you what the Supreme Court said, and you could understand the reason why they went to that conclusion. Now, this is the reason: that you cast your ballot, and the result was counted and filled in the EC8A form. The presiding officer may have problem with transmitting it to the IReV. So are you going to say that because you have your results in EC8 form, it is not in the IReV, so you now say that no, IReV is the result? So Supreme Court said no, you have your EC8 form that tells you the total number of votes that has been cast. So what I am saying is that it is not enough for that provision. It is good. It is a good development that we have electronic transmission of results as amended and proposed in the amendment, but the Senate should know better, that they should say that the electronic transmission of results should be made into section 62 sub 2, the National Electronic Registers of Voters, such that the main result should be that result that is contained in the National Electronic Register of Voters are contained in section 62 sub 2. Because right now, the Supreme Court position is that IReV is not a coalition system, and you cannot use the evidence in IReV to establish your result in an election.
So, because what a lot of people had at the back of the mind is that if the Senate goes ahead and amends that section 60 sub 5, which says the officer shall transfer And then people thought, yeah, make it electronic transmission. They thought that that was going to address the collation quagmire.
Correct.
From that perspective, that should be the intendment of the law.
Yes.
But from what you're saying now, even if you transfer it electronically, it doesn't cure the ill that the collation center provides.
Yes. Yes. And that's not what I'm saying. That's what the Supreme Court said.
Yeah, but that's what it is.
That's what it is.
Based on what the Supreme Court has said.
Yeah, so the Senate should move from just saying electronic transmission of results to defining what the coalition should be.
The Senate that has gone on recess, or okay, that's if they wanted to cure the ill.
If they want, that is what I'm saying. If they intend to cure the ill, so the Senate knows what they are doing. And if you look at the way they were laughing, I mean, I told some people that we are not supposed to be protesting. We are supposed to be mourning. They should have declared 1 week of mourning, so that we mourn because the kind of leaders we have. I think they seem to be joking.
Well, we'll have to, unfortunately, at least let it go at that point. We do have a senator coming in to join us and perhaps just shed a little more light and probably not heat on some of these matters. In just a moment, Mr. Victor Giwa, in the meantime, thank you very much for your time this morning.
Thank you for having me.
So we're back in a moment. Stay on with us.